now in session.
Please be seated. Court now calls case number CACV140341. This case is SPQR Venture, Inc. versus Andrea Robertson et al. This is a time set for oral argument. Counsel, you each have 20 minutes to present your argument. You have a clock in front of you on the podium to keep track of your time. Counsel for the appellant, you can certainly reserve some time for rebuttal. Keep in mind that these proceedings are being audio and video recorded, and the audio and video recording is going to be uploaded to the court's website, so it'll be viewed, something that could be accessed for people to view. We have reviewed the briefs, we've discussed the case, we're very familiar with the issues, so also keep that in mind as well. Ms. Borowski, you may proceed.
Morning. Thank you for allowing me to speak on this today. Lisa Borowski on behalf of SPQR Ventures, appellant in this matter. As you've pointed out, Your Honor, I'm sure the judges have had the opportunity to review the cases that we've provided and all the issues that are presented. I will boil it down and say that I believe the point of the discussion today should be the interpretation and resolution as to whether or not Section ARS 25-215B contemplates non-economic contributions from a debtor spouse. I will say that I've researched this matter in depth, and I am unable to come up with a case on point that discusses this exact issue. There are plenty of cases that discuss the event where there is a debtor spouse and a creditor trying to obtain payment through garnishing either that debtor spouse's wages or some other mechanism that is specifically economic, financial income derived by the debtor spouse. There is not, to my knowledge, a case on point that discusses contributions in the non-economic sense. However, as we've argued in our papers, and I'll argue here today, there is a well-established body of law in Arizona and nationally that assigns value to a spouse that is not deriving income purely in a financial sense by being traditionally employed. And I think we discussed several out-of-state cases that speak to that proposition. And there's a well-established body that I won't go into here today, I'm sure the court is very well aware of it, in Arizona that discusses a non-income or non-professional spouse's value that is contributed. And those are through the cases that we find in domestic relations.
Now, if we assumed in this case that the debtor spouse had income, is it your view that then you could go against the non-debtor spouse's wages?
No,
It is not.
it is not.
And that's, among other things, the Hines case.
Yes.
So why is non-monetary contribution different than monetary contribution?
I think it's important to step back and look at the statute. According to the Greyhound Arizona Racing, I might be citing that case improperly. It's the court's obligation to ascertain the meaning of a statute where it's ambiguous or there's a conflict in terms. Just going back to the statute enacted in 1973, for the stated purpose of preventing what was coined as the $2 bankruptcy, that is to avoid or abrogate one's financial obligations through the simple act of marriage, or the inexpensive act of marriage, better said. So subsection B speaks to, and I've thought through this.
So how could the University of Michigan School of Social Work
get to my assets because my wife didn't pay her loan. You know, it's her sole and separate property that was due beginning on June 1st of 1978. We got married in 81. Let's assume that she didn't work and we just raised our family. How could they do that? How could they get to any part of my income when I was a lawyer and then a trial judge just because she was a mom?
That's a very good question, Your Honor, and I think the answer is clearly that's a factual determination. I believe that would have to be what we're here for today is to decide, does Arizona law
But that's the same thing. We're here in Arizona. How does 215B allow the School of Social Work to get to my income on her debt?
Well, let's take our facts, for example. We have a husband who, based on information and belief, and this has not been controverted, has a startup tech company where he's the CEO. In a highly entrepreneurial state, there are various factual scenarios that would address the question you've just posed. Say my husband and I, for example, start a company, Nothing Bundt Cakes, let's take it for that, which I'm partial to. And we start the company together. He stays home with our children, and I derive $300,000 in income. Now, this is, in my opinion, a factual scenario that would be intentionally avoiding the obligations of my husband to not pay his prior debt. That was a judgment that was asserted against him the year before we were married. There are several crafty ways to avoid one debtor spouse's debt, and I'm sure the court has seen plenty of those attempts. I'm very surprised that this particular scenario, again, in a highly entrepreneurial state like Arizona, there are plenty of ways. I mean, I think I can't even tell you how many percentage, but I know it's high, of small business owners. There are plenty of ways to not compensate one spouse and show them as being insolvent under the statute. But in fact, I don't think the statute says that. I don't think the statute speaks to the scenario you've just posed for us here today. The statute was, I want to say careful, but that would be an overstatement.
Could be.
The statute was careful to not say, as one case points out, I believe that was anyway, as one case points out, it was not the share, which throws a little bit more murkiness into the whole discussion than even the statute. It doesn't use the term share, which would imply the 50% entitlement of community property, but what it does say is contribution. It doesn't say, as Judge Ray did, that this statute only contemplates the financial contribution, because the legislature could have used terms like the income, the financial contribution. Surely that would have been much more clear. But then it goes on to state that would have been the spouse's separate property if single. Well, that I believe is almost in conflict to the contribution comment. The contribution to the...
That is what we've said. We said in Flexmaster, that's what the contribution language means. So that in this case, the fact that if the debtor spouse were single, she would own nothing of Mr. Robertson's income.
Yes, Your Honor. There is plenty of case law that speaks to the value of contribution. For example, the case that talks about the valuation, Hennig versus Hudman. I'm sorry, it's not Hennig versus Hudman, excuse me. Of the goodwill of the business. Mitchell v. Mitchell, excuse me. Supreme Court case 1987. It's not a case that's on point, but it's as close as we get in this area. They're trying to value the goodwill in the case of a divorce. Well, they go into much discussion about how there is no goodwill that's prescribed to the non-accountant spouse. This is an accountancy firm, and they talk about how the value of the contribution made by the non-professional spouse to the success of the professional involves wife's entitlement to the value of goodwill of husband's business, same as her entitlement to increased value in stock. So it's clear under Arizona law, a spouse that is not working in the traditional sense is not valueless in the scope of the relationship. And I'll tell you some specifics here. Let's talk about our case. Some specifics here, uncontroverted material facts. This debtor spouse, the wife, was an income earner prior to marriage. She reported on their tax returns $39,000 the year before that they were married. She also testified under oath that the reason she's not working is because their childcare costs are so extraordinary they would exceed her ability to make income. Value. We have value. I'll tell you the third major value that the community has derived as a result of her not working and her being uncollectible. That is, she hasn't had to file bankruptcy. Somebody put a price tag on that. That is a huge and significant value to this community. If she were out on her own, and again, I can't figure out what the legislature is trying to say here. If she were single, if she were single, she'd be employed. She would have filed bankruptcy. That's a reverse value. That's a savings, if you will. But she wouldn't be living for free or being supported. Again, an uncontroverted material fact. Her living expenses are $3,000 to $4,000 per month. That's what goes through her accounts while staying under the $300 threshold of collectability and garnishment. So there is not a case that discusses a debtor spouse's intentional avoidance of income where it is resolved that therefore there is no value that can be derived from the community. And as Your Honor, Judge Portley points out, pardon me, there are a wide array of factual scenarios. It may not be true in the judge's case here. There's income for the wife, there's income for the husband, maybe there's no income for the wife. That might be a simpler case, but in our scenario, there is value. They're intentionally avoiding her being collectible, and I believe that this is an open question. I believe the statute is unclear. I believe there's a wide variety of ways to look at this through the cases, but not one speaks to the value of the contribution of a non-working spouse. And in our case, at least in our case, there is value being provided.
Well, we understand that as the parties who divorce, they are leaving their partnership, you have to value all of their contributions. And so the goodwill of the business or the partnership or whatever, the assets of stock have to be examined. But how do you, as the third party, get in between a married couple?
That's a very good question, Your Honor, and albeit not as artfully as we would like to have initiated this action to join the community, it's unclear how you do that under Arizona law. There is one thing that I believe is somewhat clear, that is you must join the community and the non-debtor spouse in the action. Under the Wayne Howard case, Lucia Howard she won that, and she must be able to go in and litigate what is the value that the creditor is trying to deprive her of, that the husband's contribution, again, is responsible for, that makes the community liable up to the husband's contribution. So it is clear, I believe, somewhat, that we do need to join the community. Judge Ray dismissed and foreclosed any opportunity we have to have such an evidentiary hearing on what is the value. And we're early in the litigation stage.
I was going to say, I don't know if you can get to the community, since the obligation you're seeking to cover on has nothing to do with this husband, other than the value. And if in fact we were to say that, that would be a sea change in Arizona law based upon the reading of 215B.
I would agree with you, Your Honor. I believe that the legislature enacted the statute to avoid the $2 bankruptcy. This is right in the framework of a $2 bankruptcy, although I'm sure the marriage license has gone up since then.
Oh, yeah.
Again, Your Honor, if you take this from a different perspective, the scenario that I put forth, I can orchestrate and devise a plan so that we keep my husband from collectability. I believe that's what the legislature intended. And there is not one case that tells us the opposite. I believe the cases factually are very different. There's a lot of prejudgment cases that talk about, does the community, are they joined together? Yes. The answer is unequivocally yes. I believe there's, the child support case, the Merrill and his wife, where he didn't go and work. They never say, is he not working permanently? I mean, that's the other thing about this. She may just be unemployed for the purpose of this time period. And I guess we can keep chasing her and keep doing this. But we believe under Arizona law, we have the right under 25215B to go in and value her contribution. As a matter of law, there is nothing that supports the conclusion that she has no value in the community or no value can be ascertained because she is not employed. So I'm going to leave it at that unless you have any other questions and reserve a few minutes.
Thank you, counsel.
Thank you.
Mr. Fiola?
If it pleases the court, Stephen Fiola here for Appellees. Good morning, Your Honors. I think the argument that appellant makes, that is the interpretation that appellant is asking this court to accept, would eviscerate 25215B. I mean, think of, because the appellant is trying to extend to a creditor rights reserved for husbands and wives within the marital context. Homemaking and child care certainly does have value, but it's Arizona law that says, as a community property state, that this state values that as between a husband and wife. So that what appellant tries to do is draw from alimony cases and say, well, see, this has value. But what appellant fails to do consistently in not only its opening brief, but in its reply brief, it fails to consistently analyze the entire statute. Andrea Robertson does provide homemaking and child care services. Are those services, do they contribute to the community property? And would those services have value if they were not married? If Bradley and Andrea Robertson were single and living together, this state has chosen to say there is no recognition of those kinds of community property rights.
Because otherwise they could, if they weren't married under this theory, they could garnish Mr. Robertson in the same way, because he's receiving something, he has received and is in possession of something that was given to him by Mrs. Robertson.
Precisely. And as Judge Ray suggested in the transcript, how do you garnish homemaking or child care services? So it is our position that the statute as analyzed in both all of the briefs and as modified in 1973 specifically allowed for community property to be liable, but under the specific conditions described in 25B. And
I think the example, if they're not living together, is a lot easier. If she doesn't work, she's taking care of his 5 kids, you could value how much husband or fiance is saving by not having kids in childcare. That's a lot easier, and say, because she's doing it for room and board, it's value at $10 an hour, or whatever you pay for childcare for 5 kids. But it's the community aspect
that's right.
that makes this difficult.
Yes, and that's why the rest of the statute says, which would have been such spouses, that is Andrea's separate property if single. And clearly, with all due respect to the appellant's argument, it's just not there. 25-215B, as read in terms of the definition of property of 25-2012, Judge Ray got it right. And those would be my comments. Thank you. Were there any questions, Judge Thompson? Or, no, sir. Thank you.
Justice Portley? All right, thank you, counsel. Ms. Borowski? You know, you've stroked his ego by calling him Justice today. He's not going to get over
Elevated.
this for a while.
I'm sure that happens to him a lot, though.
Not to deal with it.
Just remember that.
Mr. Fiola says that our argument would eviscerate 25-215. I think it absolutely furthers the intentions of 215B by preventing a spouse's intentional avoidance of income so that they do not pay their debt, their judgments.
Even that sort of a factual inquiry would seem to involve a substantial invasion of marital decision making. I mean, you apparently are offering to prove that Mrs. Robertson's choice to take care of children is a scam meant to avoid her financial obligations, whereas in this marriage it may be a decision that's the best thing for their children.
Your Honor, absolutely
You want
not.
to get into that and second-guess spouses' decisions about how they raise their children?
It's purely a question of value that she's contributing. It's not, the decision is fine. She could employ or
You're
not be
saying
employed.
she's intentionally doing it to avoid her obligation.
Whether she is or not, I believe that's irrelevant. I believe the statute calls for the debtor spouse's contribution. The community property is liable up to the point of the debtor spouse's contribution. The point is, it's actually very, very simple. It's whether or not a non-income earning spouse is contributing value. And I think the case law is clear in Arizona that the non-working spouse contributes value to community property, and it can be valued. It can be valued. And, invading a creditor's rights in this state are very, very strong. Do we want to invade their finances? Yes, we do. Yes, we do. There's a $240,000 judgment that's been entirely avoided here. And, maybe the value of her contribution is
Well, I mean, you can
$2,000 a month. Maybe it's not much.
Interfere with her to the extent of making her sit for debtor's examinations, and you can do what you need to do with regard to her, but the protection is for the community that she's formed with her husband.
Again, Your Honor, and we have done that, and all signs lead to the intentional, avoidance of showing income. That's really, honestly, beside the point, though, for the purpose of this hearing and this case, and our point is that 25215B does not foreclose the assignment of value for a non-W-2 paid employee spouse. That's the issue. And again, just think about my nothing bundt cakes scenario. It's not brilliant. I mean, it's very simplistic, but it would preclude recovery of a judgment entered against my husband the year before we were married. That is not the result that I believe the state legislature was trying to come up with. And so a couple other things, again, a non-disputed material fact, there is no prenuptial agreement. This is all under the community property laws in Arizona, the structure of this marriage. One other thing that...
So it's not a covenant marriage or
No.
all those extra things that might otherwise have to worry about?
No, it's just a traditional. But in any event, Mr. Fiola points out that if they were living together, she would just be deriving benefits that would be non-income or non-W-2. Again, that would be value that she is contributing and receiving, and she would not have had to file bankruptcy. She would have filed bankruptcy if she were single, excuse me. So there's huge value there as well to the community. With that, Your Honor, I have 10 seconds, and I'll entertain any questions. Oh. Thank you.
Thank you, counsel. We will issue a written decision in due course. Court's in recess.